The United States Supreme Court just issued a major emergency ruling, and it overrode two lower federal courts who had ruled on Trump's executive order, and this clears the way for Trump and his administration to put in place this executive order revolving around the upcoming elections. And while the Supreme Court did not rule that the Trump executive order is ultimately constitutional, the court did conclude that California and the 20 other states, as of right now, did not have standing to bring this lawsuit and block the implementation. The Supreme Court has now stayed a lower court injunction that prevented the Trump administration from moving forward with citizenship verification efforts, federal election law enforcement priorities, and proposed Postal Service rulemaking involving mail-in ballots. And the court concluded that the lower court there likely never had jurisdiction to issue the injunction in the first place. So in this video, we're going to be breaking down what exactly happened with the Supreme Court ruling, why the lower court injunction has now been blocked, and also what happens now going forward. Now, before we jump into what is going on with this new Supreme Court order, if you like this type of content and you want to ensure that you get updates on this as the case moves forward, make sure to subscribe to the channel and also turn on all notifications. Now, for those not aware, earlier this year, President Trump issued Executive Order 14399 dealing with election integrity. So 3 provisions became the center of this current legal battle. You had Section 2A, which directed the Secretary of Homeland Security to take appropriate action to create state citizenship lists, identifying citizens who would actually become over the age of 18 for the upcoming federal elections. Importantly, the executive order does not require states to actually use those lists. Now, Section 2B directed the Attorney General to prioritize the investigation and, where appropriate, prosecution of state and local officials or others who issue federal ballots to individuals who are not legally eligible to vote. And finally, you had Section 3, which directed the Postal Service to initiate some proposed rulemaking involving mail-in ballots. Now, in response, 23 states and the District of Columbia sued the Trump administration, arguing that these provisions unlawfully interfered with the state's constitutional authority over elections. Now, on review, a federal district court agreed and entered an injunction preventing the administration from implementing Sections 2 and 3 against those states for the upcoming midterm elections. The Trump administration then appealed and asked the First Circuit to stay that injunction. However, the First Circuit denied that stay request, and because of that, the case was then sent directly to the United States Supreme Court for consideration. And now, yesterday, we got the official decision from the Supreme Court, and they actually granted the Trump administration's application for that emergency stay. That means that the lower court injunction blocking these provisions is no longer controlling while the appeal moves forward. So in effect, that means that the administration can move forward with the implementation of the order for the upcoming elections and the upcoming midterms. But what makes this ruling particularly actually significant is why the Supreme Court granted that relief. The Supreme Court concluded that the Trump administration is likely to prevail on its arguments that the district court lacked jurisdiction over this state lawsuit in the first place. So this was ruled on based on procedural issues, and there were 2 major constitutional doctrines that came into play. First, you had standing in ripeness. So under Article 3, federal courts cannot simply decide whether a government policy might someday cause constitutional injuries. Plaintiffs generally need an injury that is concrete, particularized, and sufficiently imminent. And courts generally cannot decide disputes that depend on contingent or future events that might never actually occur. And according to the Supreme Court, that is exactly the problem here with this case and the lawsuit that was brought by the states. Starting with the citizenship list, the Supreme Court emphasized that Section 2A is essentially an internal directive from President Trump to the Department of Homeland Security. It does not order California or the other states to do anything. The states aren't required to use the list, and DHS itself can act only to the extent implementation is feasible and consistent with applicable laws. According to the Supreme Court, finding an injury to the states requires stacking speculation on top of speculation. You have to predict whether DHS will actually create the list, how will it implement that order, what actions the secretary will ultimately take, and then whether those future actions will actually injure the states. So Article 3 requires more certainty than that, and that's why the Supreme Court had an issue with this lawsuit that was brought. The states also argued that they were already spending money and resources preparing for the executive order, but the Supreme Court rejected that argument as well, and they concluded that the plaintiffs cannot manufacture standing by spending money in response to a speculative future threat that may come. The Supreme Court then addressed Section 2B and the threat of federal prosecution. The states argue that their election officials could potentially face investigation or prosecution if they refuse to use that citizenship list that was created by DHS. The states argue that their election officials could potentially face investigation or prosecution if they refuse to use that citizenship list. But the majority of the Supreme Court pointed out that Section 2A does not require states to use those lists, and they're not required to do that. The court instead characterized Section 2B as President Trump establishing these priorities and found no sufficiently credible threat that the officials would be prosecuted simply for refusing to use that citizenship list. Now, then when we get to the Postal Service aspect that was also brought up in this lawsuit based on the executive order, and really here is where the Supreme Court concluded that the challenge was even more premature. The executive order directs the Postal Service to initiate a proposed rulemaking. So there isn't even a final federal rule yet. This is simply just saying, hey, create a proposed rule. The Supreme Court pointed out that the Postal Service, through this proposed rule, could modify the proposed rule. What is in the proposed rule would never actually be the final rule likely. There would be comments, some changes that would appear. And so for the lower district court to make a ruling based on what could be in the proposed rule and really trying to determine, what they're going to implement, even though it's just purely speculation, that's where the Supreme Court had an issue with and said that this was premature, that there was not standing, and that this was not yet ripe. And the majority made it very clear that if the Postal Service eventually adopts a final rule that actually harms the state, well, then they can challenge that rule based on the final rule. Now, here's probably the most important takeaway from what happened with this order from the Supreme Court. The Supreme Court did not hold that the Trump administration's executive order is outright constitutional. In fact, the majority expressly says that, if the Trump administration ultimately takes and implements the order and, has that in place, well, that can still be challenged. The court is simply saying here that the executive order itself does not presently injure the states enough for this lawsuit to proceed. But if the executive order is implemented and some of these things are done, including the list, the change with the Postal Service and a final rulemaking, well, then the constitutionality of those can be actually challenged. Now, of course, there were dissents from the liberal wing of the Supreme Court. You had Justice Sotomayor that was joined by Kagan in their dissent, and they argued that the states already face sufficiently concrete injuries, particularly because of the relationship between the citizenship list and the threat of federal prosecution. Now, you also had Justice Jackson separately dissent, and she also raised some interesting concerns. She says that the Supreme Court has repeatedly warned against changing election rules through litigation too close to the election, but Jackson also argues that this ruling potentially creates the opposite problem. So if you bring the election lawsuit too close to the election, then it may be too late and it's too close to the election. But if you bring it before the government completely implements that policy, well, then you may now actually be too early. So she argues that this creates a major uncertainty over exactly when these election lawsuits are supposed to be filed. So where does everything go from here? Well, you have the Supreme Court stay, which remains in place while the case proceeds forward through the First Circuit. But right now, the Trump administration has scored an extremely significant emergency victory, and they can implement some of that executive order. The lower court injunction has been blocked, and the administration can attempt to move forward with these election integrity policies. And also, the Supreme Court has sent a significant message about when states can use federal courts to preemptively block executive branch policies like these executive orders. So as this case moves through the First Circuit and as the Trump administration determines how they're going to actually implement this executive order, I will be watching that and bringing you guys updates on that in this case as well. And if you want to continue to get those updates, make sure to like, comment, subscribe, and turn on all notifications so you don't miss those videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.